Assalamu alaikum. This is the next lecture in the Forensic Secret series, and in this, we'll today be discussing a very important topic, that is Qisas and Diyat Act, and this is the one topic that is most important. When to apply what section? Please, for God's sake, just be careful about that. You should know when to apply what section. And for this today, I'm going to make sure that you are going to unlearn what the wrong things you have already learned. The old hear and say things that you have learned. The old rituals that are being followed, especially in the case of dental injuries. The stupid section of italafe dant, this is no term. It is no legal term, it is no medical term. So in today's lecture, I'm going to make sure that you are going to unlearn all those things that have been just, I don't know from where they have erupted, I don't know from where they have gained their roots, but somehow they have really strengthened their false beliefs into your minds. And these are the delusional facts that have nothing to do with the law and nothing to do with the legal aspect of the injury. You know, as forensic medicine is the medical aspect of law and legal aspect of medicine. The legal aspect of medicine is to be quoted that can be backed up by some reference. How come that you can just imagine things and then just make up things and then quote those things in the sections of the nature of the injury? So please, this lecture is very important and you have to listen it completely till the end so that you should know what section to apply on which injury and when and how to apply the legal sections. To begin with, again, we'll be dealing with some definitions that are not only exclusive to Qisas and Diyat, but also part of Pakistan Penal Code. So the injuries and the legal implementations and all those things, they all go hand in hand. The Sharia courts are also applicable and active in Pakistan. The PPC Act is also applicable. The Qisas and Diyat Act is also in play. The Women Protection Act is also in the play. All these things, they act in hand in hand. They act in collaboration. So you need to know all those things. At least you have to have a bird's eye view of everything so that you can appreciate it and technically apply it when required. Okay. To begin with, first of all, we have to define injury as per Pakistan Penal Code. Section 44 of PPC says that any harm, whatever illegally caused to any person in body, mind, reputation, and property. So these four things are part and parcel of definition of an injury in Pakistan Penal Code. Any harm done to body, mind, reputation, or property comes under the heading of injury. And then again, the clinical term wound has no legal value. So you have to write down injury, not wound number one, wound number two, it's injury number one, injury number two. Okay. Next is 299C. The authorized medical officer means a medical officer or a medical board designated authorized by the provincial government. Then 299L, Tazir, means punishment other than Qisas, Diyat, Arsh or Daman. So Tazir is a punishment that is applicable in Pakistan Penal Code other than the compensatory acts like Qisas, Diyat, Arsh and Daman of Qisas and Diyat Act. Next, what is Qisas? It falls under section 299K and it states that punishment by causing similar hurt. Just listen to it. Punishment by causing similar hurt at the same part of the body of convict as he has caused to the victim, or by causing his death if he has committed Qatle Amad in exercise of the right of the victim or a wali. So you understand? It's tit for tat, an eye for an eye, a life for a life. That is qisas. Then next comes 299E diyat, the compensation specified in section 323, payable to the heirs of the victim by the offender, and the value is to be decided by the court keeping in view the financial position of the convict, the financial position of heirs of the victim, value of 30,630 grams of silver to be announced by the federal government on the 1st July every year, which is presently amounting up to 6,757,902 for the financial year of 2023 and 2024. Okay. After Qisas and Diyat, there are two more important compensatory monetary compensations. That is falling under the section of 299B, which states the arsh of it, and 299D, which states the daman of it. Now, what is arsh? Arsh is a legal section that is specified by 299B, and it states that compensation specified in this chapter to be paid by the offender to the victim or his heirs only applicable to hurt cases, not in cases of death. In cases of death, it's only qisas or diyat. Any other case in which any body part is involved, any damage to the body is done, that in that case arsh is to be paid. And what is arsh? It is to be assessed as a certain percentage of value of diyat, like 1/3 of the diyat, 1/2 of the diyat. So it is specified in law. Diyat is fixed as per value of the 30 gram, 360 grams of silver, and arsh is the percentage of the diyat according to the hurt caused by the assailant on the body of the victim. And then there's a slight relaxation is in it, that if it is not possible for the assailant to pay the amount in a lump sum amount, then he can pay the victim it in installments as the court orders. Next is 299D daman. Daman is again also a monetary compensation, and it is determined by the court to be paid by the offender to the victim for causing hurt not liable to arsh. So all those injuries that are liable to arsh have already been specified. So in cases like in death cases, it's only qisas and diyat. And then there are certain defined cases in which only arsh is applicable and arsh is to be paid. And all those injuries do not either fall under death or fall under the compensation of earth are to be compensated through daman. And daman is the amount of monetary compensation specified by the court, and the value of daman may be determined by the court keeping in view what the expenses occurred on the treatment of the victim, the loss or disability caused in functioning or power of any organ, and then finally the compensation for the anguish suffered by the victim. So this is daman. Now, as we defined injury under section 44 of Pakistan Penal Code, now comes the Qisas and Diyat definition, and it defines it as hurt. Now here I would like you to appreciate the difference. The hurt falls under section 332 of Qisas and Diyat Act, and what is it? Hurt is committed by anyone who causes pain, harm, disease, infirmity, injury to any person, which impairs, disables, dismembers any organ of the body or part thereof of any person without causing death. So keep in mind that this does not cover any psychological issues like harm in the mind, any issues of the property, or any damage to the reputation. Hurt doesn't cover that. Hurt is only covering the bodily pain, the bodily harm. the bodily disease, the bodily infirmity, the bodily injury, which is impairing, disabling, or dismembering any organ of the body. So this is hurt. And then hurt is further subclassified into itlaf-e-udh, that is loss of an organ, itlaf-e-salahiyat-e-udh, loss of functioning capacity of an organ or permanent disfigurement. Shaja, which covers the injuries inflicted to the head and face. Jur is further subdivided into Jur Jaifa and Jur Ghair Jaifa. That is the injury to the body other than head and face. And then finally, all kinds of other hurts. This is the subclassification. Okay, starting with Itlaf-e-Udh. It is covered by the section 333. And whoever dismembers, amputates, severs any limb or organ of the body of another person is said to cause itlaf-e-udh. Now, one thing that is most important that I want you to unlearn here is that you are not going to write section 333 or 334. You are going to write itlaf-e-udh. Writing down itlaf-e-udh is the duty of the medico-legal officer. Writing down the legal section is the duty of the medico-legal officer. You have to write itlaf-e-udh, you have to write itlaf-e-salahiyat-e-udh, you have to write shaja khafifa, shaja mawdi'a, shaja hashma, and etc. 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 Similarly, jurghair, jaifa, damya, abadiya, mutlahima, whatever. You are not going to write 337A1, you are not going to write 337F1 and things like that. That is not your duty. That is the duty and prerogative of the honorable courts. So unlearn this, please, once and for all. Even if the police one pleads you to say, please, Doc Sahab, write 337A1, please, Doc Sahab, write 337A2, you're not obligated to write that. You are under no obligation to oblige that police person. What happens? You are going to write section as itlaf-e-udh, and then there is the legal wing of the police station. They are supposed to put 333 there. And then court has the prerogative to put section 334, which is the actual punishment of itlaf-e-udh. So if you are going to write 333 or 334, then what's the use left for the police stations or the courts then? Then you are playing the doctor, you are playing the judge, jury and executioner and everything. So it is the ruling of Supreme Court. Please mind it. You can be liable to punishment and penalty if you do not obey this. So unlearn this. Whatever you have learned in your mind, you are not going to write the sections at 337A1, A2, A3. No. You have to write the exact section that falls under the legal wording of it, like itlaf-e-udh. So, whoever dismembers, amputates, severs any limb or any organ of the body. Now, some organs are paired, like upper limbs and lower limbs, they are paired. Ears are paired, eyes are paired, breasts are paired, kidneys are paired, testicles are paired. And an organ is here, parathyroid glands that are quadruple. Then the eyelashes, they are quadruple. So, whoever is going to dismember, amputate or sever any limb. If one limb is cut, you have to write down itlaf-e-udh. Next, judge is going to decide that the punishment for that is going to be half itlaf-e-udh, as this is a paired organ. So that is the legal implication that you need to consider and re-register it in your mind. Next, coming on to section 335. That covers itlaf-e-salahiyat-e-udh. Now, itlaf-e-salahiyat-e-udh, it then covers two parts. That is the loss of the functioning capacity of an organ or permanent disfigurement that cannot be repaired through any cosmetic surgery, any prosthetic surgery, any sort of repairing surgery, whatever surgery, like orthopedic surgery, like general surgery, like any surgery. If it is unable to repair that organ, and it is going to have a permanent damage either cosmetically or in the functioning capacity of it. That falls under section 335, but you have to write italafe salahite ud. You are not going to write section 335. That is the duty of the legal wing of the police department. And then further, 336A and 336B are the subsections of this section. Okay, now let's define it in the legal terms. What it says whoever destroys or permanently impairs the functioning power or capacity of an organ of the body of another person or causes permanent disfigurement is said to have caused italafe salahiyate ud. And it is to be punished with qisas, and if qisas is not executable, then offender is liable to ash. Along with tazir. I already defined you tazir in the beginning of the lecture that it is the punishment as per Pakistan Penal Code. So monetary compensation is to be paid under the legal heading of arsh, and tazir is 10 years punishment in this case. Next, 336A. Now 336A defines a hurt caused by a corrosive. People are damaging other individuals, especially females, by throwing acid on their faces. It causes permanent disfigurement. It cannot be repaired through any surgery, any cosmetic surgery, or whatever procedure that you can think of under the sky. The damage is so much done that the corrosive burns the skin of the face so much to that much extent that is irreparable. So whoever with the intention or knowingly causes or attempts to cause hurt by means of a corrosive substance which is deleterious to human body when it is swallowed, inhaled, comes into contact or received into human body or otherwise shall be said to cause hurt by corrosive substance. So I want to make sure that you understand it here, that whether it is swallowed, whether it is inhaled, whether it is comes in contact with the skin or any other body part, or any way received into the human body, like intravenously or something like that. Enema is given, intravenously is given. All those forms of corrosive agent which cause damage to the body are defined by section 336A. And then this section further defines the corrosive substances. Now, this subsection further defines what a corrosive substance is. You also need to know what a corrosive substance is. It is any substance which may destroy, cause hurt, deface, or dismember any organ of the human body, and it includes every kind of acid, poison, explosive substance, heating substance, noxious thing, arsenic, or any other chemical which has a corroding effect and which is deleterious to human body. So understand once again that all these things cause damage to the body, which might cause the loss of functioning capacity, or it may cause the permanent disfigurement. These include explosive substances, acid, poison, heating substances, noxious things, arsenic, or any other chemical having any corroding effect. Finally comes the section 336B. The punishment for hurt by corrosive substance. Now this is to be applied by the Honorable Court. You are not going to write 335 or 336. You are not qualified to do that. So what says section 336B? Whoever causes the hurt by corrosive substance shall be punished with imprisonment for life or for imprisonment which shall not be less than 14 years and a minimum fine of 1 million rupees. So you have to decide very carefully that the injury falls under section 335 italafe salahite ud, and you have to write it as italafe salahite ud. I hope that I am getting through to you and the message is loud and clear. Okay, now we defined italafe ud and italafe salahite ud. The next is the injuries caused to the head and the face. That is covered by shaja. And what is the definition of shaja? Shaja says that whoever causes on the head or face of any person any hurt which does not amount to italafe ud or italafe salahite ud is said to have caused shaja. Now, let me make this point clear here that there might be an injury to head and face that might cause loss of an organ, like eye is lost. If eye is lost, then it falls under italafe ud. Or if the vision is lost, then it falls under italafe salahite ud. A tooth is lost, it falls under the section of italafe salahite ud, loss of functioning capacity. If the muscles of the face are damaged and there is permanent disfigurement, then it falls under italafe salahite ud. So any injury which is not going to amount to either italafe ud or italafe salahite ud and is in the region in the area of head and face, it falls under shaja. And let's now further specify and subclassify shaja. Number one is shaja khafifa. That is any injury that occurs without exposing the bone of the victim. Now, this is the scalp, and the forensic anatomy of the scalp is that it's only 5 to 8 millimeter thick. So, sometimes there is an injury in which the underlying bone is not exposed, and that falls under section shaja khafifa. And the diyat for that is daman plus 2 years of punishment as tazir. So, again, there is a further subclassification here which I need to specify. Some of the offenses are cognizable. That is, police can register an FIR against that offense directly without involvement of any court. And a few of the injuries, they fall under non-cognizable offenses. That is, the police is not authorized to register an FIR in that case until and unless there is a court order. And for example, in this case, the shaja khafifa injury, it's a non-cognizable offense. So it doesn't mean that the assailant is not going to be punished. It doesn't mean that the victim is not going to get any compensation. That's a wrong misconception. Again, this is a misconception that has been poured into the heads of the victims by the illiterate paramedical staff or by the less knowing police officials. As it is not cognizable, as it doesn't fall under the cognizance of the police, that's why they misguide the people that section shaja khafifa, it's a useless section. You need to get a better section for that so that police can register an FIR. Police is obligated to refer an FIR anyway once the court order comes to them, even if it's a case of shaja khafifa. And it is punishable by daman. And I already told you, daman is the monetary compensation that is decided by the court. And it is also punishable by 2 years of tazir under PPC. So please, please, please do not misguide the victims and do not play into the hands of corruption. And please learn the new things that are being guided to you through these training sessions. Unlearn all those previous things that are just hearsay. Next comes shaja maudiya. Shaja maudiya is the injury in which there is exposure of the underlying bone, like damage to the scalp, like damage to the face, that underlying maxilla or mandible is exposed, underlying nasal bone is exposed, any of the skull bones are exposed. That injury falls under shaja maudiya when the underlying bone is exposed. And please, 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 again, unlearn this illegal or irrational terminology of bone deep. What do you mean bone deep? There is no such thing as bone deep. What do you mean bone deep? Bone is either exposed or not exposed. So please stop writing bone deep or bone not deep or something like that. Just write down underlying bone is exposed or not exposed. And if there is a bleeder, if there is extensive bleeding, do not try to probe in. the depth of the injury, just keep under observation for the treatment notes to come from the surgical department. And then you can decide whether underlying bone was exposed or not. And again, in this case, the monetary compensation is, here comes the arsh. It is 5% of the diyat. So if underlying bone is exposed and it falls under shaja modiya, it has a monetary compensation of 5% of diyat and plus 5 years of tazir as punishment, as imprisonment. So you need to know this. Next comes shaja hashma. Shaja hashma is an injury that causes the fracture of the bone of the victim without dislocating it. It could either be fracture of the skull bones, it could either be the fracture of nasal bone, it could either be the fracture of maxilla, mandible, or any other bone of the face and head without dislocation. And again, the monetary compensation in this case is arsh, 10% of the diyat. It has already been specified. I told you that arsh means that the specified percentage of the diyat that is already been decided by the court of law. Plus 7 years of tazir as his imprisonment. So these are the things that should be known to you. Next comes shaja munakala. It is the fracture of the bone of the victim and thereby along with dislocation of those fractured fragments. And it is compensated by 15% of diyat and plus 10 years of tazir imprisonment. Next in this classification is shaja ama, that is causing the fracture of the skull of the victim so that the wound touches the membranes of the brain. The wound that exposes the meninges and touches the membranes of the brain is resulting in shaja ama. So, fracture of the skull of the bone touching the membrane of the brain falls under shaja ama, and the monetary compensation is 1/3 of the diyat plus 10 years of imprisonment as tazir. And then finally, the last section in this case is shaja damega. It is the fracture of the skull of the victim and the wound ruptures the membrane of the brain and the brain is exposed. And in this case, the monetary compensation is half of the diyat plus 14 years of imprisonment as tazir. So all these things have been defined like this. Now, if you want to know the legal section that as a punishment that judge is going to apply, they fall under 337A1 to A6. But you are not going to write 337A1. You are going to write shaja khafifa. You are not going to write not going to write 337A2. You are going to write shaja modiya. You are not going to write 337A3. You are going to write shaja hashma. You are not going to write 337A4. You are going to write shaja munakala. Similarly, you are not going to write 337A5. You are going to write shaja ama. And finally, you are not going to write 337A6. You are going to write shaja damega. So please unlearn all these things and try to adapt and follow these things that have legal value and legal worth, and they are going to save your skin. Otherwise, you are going to fall prey to the legal complications. Beware of that. Okay. So far we have discussed itlafeud, itlafe when shaja. Now coming to jur. Jur is covered by section 337B. Now what is jur? Whoever causes on any part of the body of a person other than head or face a hurt which leaves a mark of the wound, whether temporary or permanent, is said to cause jur. So try to understand any part of the body other than head and the face. A hurt which leaves a mark of the wound, whether temporary or permanent, is said to have caused jur. Jur is of two kinds, namely 2A, jaifa, Whoever causes jur in which the injury extends to the body cavity of the trunk is said to have caused jaifa. So body cavity, chest cavity, or the abdominopelvic cavity, any cavity of the trunk, if it is either penetrating or perforating, extending to the body cavity of the trunk, that falls under jur jaifa. And that falls under 337C. This is to be applied by the legal wing of the police. And the punishment for jaifa is 337D, which is liable to arsh, which is 1/3 of the diyat, and may also be punished with imprisonment of either description for a term which may extend up to 10 years as tazir. So that is jaifa, jur jaifa. Now, after jur jaifa comes jur ghair jaifa. And let's see what falls under jur ghair jaifa. Whoever causes jur which does not amount to jaifa is said to have caused ghair jaifa. So any injury which can penetrate or perforate the cavity of the trunk, either chest or abdominopelvic cavity, falls under jaifa, and any other injury other than that falls under jur ghair jaifa. Now, in this case, the jur ghair jaifa is further subclassified into jur ghair jaifa damia, in which skin is ruptured and bleeding occurs. So, just focus on this part of it, that the skin is ruptured, and the monetary compensation in this case is daman plus 1 year imprisonment of tazir. Then next is jur ghair jaifa badia. It is the cutting or incising of the flesh without exposing the bone. And it again has a monetary compensation of daman plus 3 years of imprisonment as tazir. Next is jur ghair jaifa mutlahima. It is the laceration of the flesh. Lehem. Lehem means flesh. It is the laceration of the flesh and without exposure of the bone. It is again compensated by daman and 3 years of imprisonment as tazir. Then jur ghair jaifa maudiya, in which the underlying bone is exposed. Now in this case, whether it is an incised wound or a lacerated wound, but the underlying bone is exposed, it falls under jur ghair jaifa maudiya, compensated by daman plus 5 years of imprisonment as tazir. Coming next in line is jur ghair jaifa hashima. It is the fracture of the bone without dislocation of the bone, covered by monetary compensation of daman and 5 years of imprisonment as tazir. And the last subsection of jur ghair jaifa is jur ghair jaifa munakala. It is the fracture and dislocation of the fractured fragment of the bone, covered by daman and 7 years of imprisonment as tazir. So most of the shaja monetary compensations are covered by arsh, and almost all of the jur ghair jaifa monetary compensations are covered by daman. Now, another important section to be mentioned here is section 337J. Whoever administers to or causes to be taken by any person any poison or any stupefying, intoxicating, or unwholesome drug or such other thing. It could either be a poison, it could either be a street drug, it could either be a pharmaceutical preparation, it could either be a recreational drug, or it either could be alcohol. So any of the things which cause stupefaction, intoxication fall under section 337J. And in this case, as there is no terminology involved in this, so if an alcohol case or a poisoning case or intoxication case comes to you in this section, it is an exception here that you will have to write in nature of injury 337J. And there is no legal term implied to this section. It is an exception. So don't make it a habit, don't make it a rule of thumb that if you can write 337J, then you can write 337A1 also. Then you can write 337F1 also. No. There are two sections, rather three sections, which do not have any name. That is 337L1, 337L2, and then 337J. These are the routine sections that you will come across during your medical legal work, and you will have to apply these sections. So be careful about these sections. I am emphasizing on it over and over again, and I am telling you the exceptional sections that can be written as 337J in cases where and when required. Okay. Next, coming on to 337L. This was the one that I was already talking to you about. 337L1, whoever causes hurt not mentioned herein before, which endangers life. Number one. Number two, which causes the sufferer to remain in severe bodily pain for 20 days or more, plus renders him unable to follow his ordinary pursuits for 20 days or more. That falls under section 337A L1. That falls under section 337 L1. So mostly you have seen that the gravity of the situation and the gravity of the legal hurt and the monetary compensation and the tazir punishment gradually increases from A1 to A6. And it increases from Shaja Khafifa to Shaja Damega. And it increases from Jurgair Jaifa Damea to Jurgair Jaifa Munakala. But in this case, the 337 L1 is the one that is more grievous as compared to 337 L2. And what is 337 L2? Let's see. Whoever causes hurt not covered by subsection 1 shall be punished with imprisonment of either description for a term which may extend to 2 years and compensated with daman or both. An example of the injuries that fall under 337 L2 are dislocation of a joint, simple swelling with no overlaying abrasion or underlying fracture, bruises less than 25% of the body surface area except head and face, burns less than 25% of the body surface area except head and face. Why head and face is an exception? Cause it might cause permanent disfigurement. The bruises may damage to the extent that they may cause permanent disfigurement. In cases like when bruises, they usually tend to disappear after the disintegrating, degrading decomposition byproducts of hemoglobin. But somehow, sometimes, there are the melanocytes and the melanin deposition that causes deposition in the skin, and it might cause a permanent disfigurement. So that's why bruise and burns less than 25% of the body surface area fall under 337 L2. And in case if it's a bruise of like say 5% or a burn of 5% of head and face, then it falls under Shajja Khafifa. It's not going to fall under 337 L2. I hope that I've clarified these points to you. The final section of this Qisas and Diyat Act falls under section 338. Whoever causes a woman with child whose organs have not been formed to miscarry, if such miscarriage is not caused in good faith for the purpose of saving the life of the woman or providing necessary treatment to her, is said to have caused iskate hamal. 337A covers iskate hamal. Whoever causes iskate hamal shall be liable to punishment as tazir. Now, iskate hamal is being covered as 338. So, if it is a miscarriage of a child whose organs have not been formed, it is going to fall under iskate hamal. Again, you are not going to write section 338, you are going to write iskate hamal. And the punishment for iskate hamal is falling under section 338A, which is to be applied by the Honorable Court, which states that whoever causes iskate hamal is liable to punishment as tazir with imprisonment of either description for a term which may extend to 3 years if iskate hamal is caused with the consent of the woman. Now here this is again important. Sometimes you know what happens, the woman is being forced to get a miscarriage done. He's forced by the husband, he's forced by the boyfriend, she's forced by the husband, she's forced by the boyfriend, she's forced by the in-laws, or she's forced by her parents to get a miscarriage done. In that case, the woman is not consenting and she is not liable to punishment. But in case if the one who is carrying out the miscarriage, one who is getting it carried out, they are both liable to punishment. And if the woman is also consenting to the procedure, then again she is also liable to punishment. Next is section 338B. It covers iskate janeen. Whoever causes a woman with a child, some of whose limbs or organs have been formed, to miscarry, if such miscarriage is not caused in good faith for the purpose of saving the life of the woman, is said to have caused iskate janeen. And this is again covered by the legal section that is applied by the courts is 333 is the section 338C, which is the monetary compensation of 1/20th of the diyat if the child is born dead, full diyat if the child is born alive but dies as a result of any act of the offender. Punishment is tazir with the imprisonment of either description for a term which may extend up to 7 years if the child is born alive, otherwise than as a result of any act of the offender. So now these are the monetary compensation and the tazir punishments in cases of these injuries. So finally, we are at the end of the lecture. So if so far you have any questions, please do leave it in the comment box and do let me know so that I can further help you out with all these sections. And please, for God's sake, unlearn all those things, especially the one in the case of dental injuries. If a tooth is being lost due to trauma, even if one tooth is lost due to trauma, it falls under italafe salahite ud. It's a loss of functioning capacity. Because if one tooth is lost, the corresponding tooth, the functioning capacity of the corresponding tooth is also lost. Because the upper and the lower jaw, they act in accordance. Either they have to bite or chew, or tear the bite or whatever, like flesh or anything that you are eating. In that case, the both the upper and the lower jaw, they do it in collaboration. So if either the lower jaw tooth is lost and the corresponding upper tooth, it becomes useless. So that falls under loss of functioning capacity, italafe salahite ud. And any mobility of the tooth other above than grade 3, grade 3 and plus, falls under italafe salahite ud. Even grade 2 mobility is to be kept under observation, and if it deteriorates down to grade 3, it will fall under italafe salahite ud. So loss of functioning capacity, permanent disfigurement, they fall under italafe salahite ud. Italafe dant or italafe tooth is no legal section. Please be aware of that. That is the take home message for today. And if you have any questions, please do let me know. So till then, take care. Allah Hafiz.